Good morning, it's Alex Woods here, financial mis-selling litigator, and it is part 8 at long last. I have been hanging back on the part 8 question of my scintillating 10-part series into bringing a practical insight into the ins and outs of the glorious guidance note. And I have been doing that because the climate, in terms of whether or not the debtor should get anything out of the refund in the case of a payment protection insurance claim, there's been somewhat of a sea change in terms of both us, in terms of the service companies actually doing the work on behalf of the insolvency practitioner, and also some realities that have come to light in terms of the costs and complications and headache of running payment protection insurance claims within IVAs and bankruptcies generally. So I'm going to run my usual routine here, which is to go into dip into the guidance note. Then I'm going to talk about a few issues. I'm going to conclude with a couple of short notes on set-off and limitations and on the issues as I see it going forward, because rather than giving the debtor client a bit of windfall or allowing them to keep the refund, the climate has somewhat changed so that now I think one would expect an insolvency practitioner to be quite, I was thinking of the word aggressive, that's not the right word, quite firm in dealing with a debtor client, not only within the IVA or bankruptcy itself, but post-completion. That's more relevant for IVAs and bankruptcies, post-completion. And that's why you need to hang on to the end of the video. So what does the guidance note say about this issue of what the debtor's getting out of it? Well, very little. 9.2, if an insolvency practitioner is using a service company, a claims management company, then they should make sure that the debtor is treated fair and reasonably, which is no more nor less than you'd expect. Obviously the debtor technically is as much of a client as the creditor. But I mean that's worthwhile bearing in mind, that one should behave in a fair and reasonable way, and at the risk of sounding like the crack record, I do think the equitable approach should be taken at all times, and that is your fallback or backstop position, or your the yardstick to use in dealing with any payment protection and financial mis-selling claim within an IVA bankruptcy, is to make sure that the thing is done in an equitable fashion and an equitable resolution is made. Time was when I thought that one should look at the letter of the law, but I'm now of the view that simply you should be saying to your creditors, no individual creditor should be preferred within an IVA, so you shouldn't be using set-off arguments. Limitations, that's something I'm going to post on in a subsequent bulletin. Anyway, I'm digressing. So I think, as I say, there's been a sea change. So originally I envisaged the insolvency practitioners actually using that £500 windfall clause to give the debtors a little bit of cash in order to assist in administering, making a claim, filling out a questionnaire, and perhaps also potentially also there's the potential of some litigation. And I don't just say that in terms of going to court, I'd say that there's a potential of the need for a witness statement preparatory to some litigation in order to deal with the quantities of FOS appeals. So let me just clarify that point. You may need to get the debtor involved. You may need to get the debtor involved because you will want a proper witness statement if the lender rejects the claim and an appeal is made to the Financial Ombudsman Service. Now, I am dealing with a small number of FOS claims, and there are 50 odd FOS claims going through the law firm that I'm consulting to. And I'm finding that some of them, we don't know how many yet because they're still in the pipelines of FOS, and FOS are saying they're taking sometimes up to 18 months to adjudicate these claims, that once they've come out the other end, if they may have been rejected by the adjudicator. Or during the course of that adjudication process, there may be a need. What I'm trying to say is that you may need to take a witness statement from the debtor client. And the reason is because a lot of these things are factual, one word against another, and if you've got a good witness statement and some documentary evidence to support that, it will help the adjudicator come to the right decision during its journey through FOS. Okay? Post FOS, it will then, that witness statement will then obviously stand as preliminary statement for a bit of litigation going forward. You know, I'm talking to the insolvency practitioners who are interested in mining their financial mis-selling claims within IVA and bankruptcies to the maximum. Those are the people I'm interested in. I'm not talking to the big volume operations, because they just want turnover. They're after turnover. I'm talking about mining claims to the maximum. So that's why I think that ultimately you do need to take an equitable view of whether or not the debtor client is going to get anything out of it. And it may be equitable to give something to the debtor client in the way of a windfall. I say windfall, and I know there's dispute as to whether or not a windfall clause up to £500 in an IVA agreement, you know, whether PPI is a windfall. But I think that an IP can, with balls, can simply exercise their discretion to make you know, to use a little bit of a carrot, but that being said, there is a sea change, and the insolvency practitioners are now having to deal with audit fees, which are charged in respect of IVAs and bankruptcies to the service companies if they're using service companies. We're discovering that it is not incredibly straightforward to process payment protection insurance claims within IVAs. The banks are up a lot of problems. I mean, the most cunning plan and strategy that you can ever have conceived in dealing with a payment protection insurance scandal is incompetence, and that's the approach that the banks take. Don't pay people very much. Don't use people as sufficiently well qualified. Instead, you just create this revolving door of complications and, you know, issues and questions and paperwork and correspondence, and you eventually exhaust your opponents, i.e. the law firms, the CMCs, the IPs who are dealing with this problem, until they until they give up, throw their hands in, and they'll just take what's on offer. Or they won't bother altogether. It's a very good strategy, isn't it? Because, you know, it dries you out. It dries you out. You have cash flow is the big issue for a law firm or claims management company in terms of a PPI mis-selling operation, and you just want to drip feed. You know, you want a drip feed approach to settling claims if you're a bank's complaints department. So, consequently, the service companies and the law firms are having to charge audit fees, quite rightly in my view, to cash flow their operations, and I suspect that there is competition from some claims management companies undercutting the 30% fee for the service company, and one can see that this is becoming something of a headache for everybody. And, you know, by the way, you should listen to a future post that I'm going to do on mining one's financial mis-selling claims to the max, because I actually think that there is profits to be made from financial mis-selling claims for both service companies and insolvency practitioners. but I'll post about that in a later video. So because it is quite administratively complicated and reasonably costly to process this stuff, there's been a climate change. When I first set up and ran a unit at Ferguson Solicitors, we were talking about giving some of the refund to the debtor client. Now nobody is talking about that. Ultimately, the duty is on the debtor client to ensure that the IVA is run efficiently and effectively to term, and the refund helps to oil the wheels of their IVA. So I mean, that comes onto the point that actually what the debtor clients are getting out of it is they're getting the peace of mind that there is sort of some oil in the engine, so to speak, in terms of a little bit of extra cash flushing through the IVA. Perhaps it gives a tiny little bit of extra cash to the insolvency practitioner. It keeps the creditors sweet. If the debtors want to settle the IVA early, for example, then financial mis-selling claims paid into their IVAs may assist that. And of course, some IVAs, some bankruptcies will have very large PPI claims indeed. I mean, some are very large. Some are very large. So, it's horses for courses slightly. But in terms of paying the debtor client a part of the refund or utilising a windfall clause within the IVA proposal, that I don't know of anybody who does that within the 20-odd insolvency practitioners whom I'm reasonably familiar with. We're not talking about large insolvency practitioners. We're talking about a maximum of 1,000 IVAs, and on average, 50, 100, 200 IVAs. That's the profile of insolvency practitioner clients that the law firm that I'm consulting to working with, and the claims management company that I have a relationship with is working with. So the bigger question, therefore, is not so much the issue here is not so much whether the debtor clients are getting a share of the PPI proceeds, because they're not. The key issue is, as an insolvency practitioner, are you faced with the risk of a debtor client keeping very quiet or being non-cooperative about their potential PPI claim and not returning the debtor pack, because specific to IVAs, you do actually need the signature of the debtor client. Obviously you don't with the bankrupt, but with an IVA you need the client to sign up to processing a PPI claim. So the problem the insolvency practitioner faces is the debtor clients, a rump of debtor clients keeping quiet and not cooperating. Now, our stats, this is the stat that I expected the set-off stat to be a big stat. I expected 33%, 40% of our claims to the banks to a fault set-off. It's more like 3%. But there's a bigger problem with debtors returning packs. And if you're having to put work and energy into having to return debtor packs, that's not something you want to do. It stretches out the length of the claim, etc., and it creates extra work, extra costs, etc., etc. Perhaps 40% aren't returning the packs. And the question then is, well, 2 years ago, I was of the view of, well, we use a bit of a carrot to get them to return the packs. Now, it's more of a hardball approach to the debtor clients to say to them, look, you are under a duty to cooperate with your insolvency practitioner. You have got to return the pack. You've got to complete the questionnaire, and you've got to cooperate with the service company if you're using a service company for purposes of processing your payment protection insurance complaint, or other financial mis-selling claim like an interest rate swap. so which would need even more cooperation. So it's a good habit to get into as an insolvency practitioner, to be quite to address this issue. Make sure that you're addressing this issue. Now, I have flagged this caveat that you should take an equitable view, and you've got to look at each and every debtor client, and those who are behaving well and are trying to settle early, you take a different view, don't you? But and I think you're entitled to take a different view, because there is no letter of the law in a lot of this area. I mean, look, this guidance notice is riddled with uncertainty and the need to consult a lawyer for legal advice on various issues. So I think you can come back to this. Well, let's have a look at the facts and see what is equitable in the circumstances. Anyway, so this is an issue, because obviously there's a rump of debtor clients who are waiting for the completion of their IVAs and who are going to make a claim post completion. Now, they need to be told two things. They need to be told three things. One, during the currency of the IVA, they need to be told that, look, if you think you've become aware of the existence of a payment protection insurance claim, and now that the scandal is broken, people can't pretend that they weren't aware of the existence of potential existence of payment protection insurance across a quantity of their debts. 3.2 per IVA. That's a third of all debts. People can't pretend that anymore. If you're just waiting for the clock to run down and you're going to make a PPI payment post completion, think again, because we won't give you your completion certificate, and if you don't cooperate, we may even fail your IVA and you'll end up in bankruptcy, because we're struggling as a medium or small insolvency practitioner. We're struggling to make this financially viable debt management tool, and it's a really good tool. We don't want to put you into a debt management plan which we might make more money from. We want to put you into an IVA. You got to cooperate, and you have got to cooperate. So going forward, if you're setting up an IVA, make sure that the debtor client is clear that they're going to have to cooperate with payment protection insurance claims. They're not going to be able to wait for the completion of the IVA before you give them their certificate. So that's the first thing. The second thing you might like to tell them, or debtor clients out there who might be listening might like to know, is you may well run into problems with the banks, because I don't think they're going to be as friendly on set-off arguments as they will have been during the currency of the IVA. They have preferred to have dealt with payment protection insurance during the course of the term of the IVA, and so they're not going to be as friendly towards set-off. And I have, and you're going to have difficulty, because what are you going to do if a bank says, sorry, we've kept the account open? I'm talking from experience. We're setting off. Well, you're going to instruct a lawyer? Well, you're going to need some money for that. The lawyer's going to want to take a large chunk of your claim, and I don't think the lawyer's going to work for free from day one, because there is such complexity that they're going to. If I was going to be taking on your case, I'd want an upfront fee from you, a £500 to pay an audit fee, if you like, because I have to spend time looking at the individual circumstances of your claim. So, so be careful. You may run in foul of set-off, and you may be in the right, but you won't have the resource to fight it. And if you can't enforce your legal rights, you're stuffed. The other issue, I think, potentially is limitations, because whilst, and I will post on this in a future bulletin, whilst limitations is not as big an issue as some people might imagine out there, and in talking to insolvency practitioners, whether bankruptcies or people in IVAs, the Financial Ombudsman Service, providing, in most cases, there are issues such as pre-2005, whether or not the bank was a member of the FSA pre-2005, but in most cases the Financial Ombudsman Service doesn't put a limitations period on financial misselling claims. The law also doesn't put, generally speaking, doesn't put a limitation period on payment protection financial misselling claims under a particular head of law, the unfair relationships test, the law as it currently stands, providing the account is still live, and I think on balance, even though your debt has gone into an IVA or been frozen, the account is still open, the matter is still live, the credit card or the loan has not been closed, then you can go back as far as you like. And I'm running some payment protection insurance litigation claims that go back to 1995, I think, and further. So, but I think that you will start to have a problem because because the banks will argue that your credit card or your loan is now completed, and therefore you don't have the luxury of saying, well, you know, my account or my credit card it's still open. So those are the three areas one needs to be alive to. Warnings to debtors about trying to do their own claims post completion. They might run into trouble unless they've got a service company to assist. We have got some post completion work coming our way. Insolvency practitioners tend not to want to take a slice of that as trustees post completion. Again, a debatable legal area. But I think those are historically old cases. I think going forward, with new cases of people who are about to pop out of their IVAs, providing they've been written to and it's been explained to them that they have a potential payment protection insurance claim, those debtors are going to run into choppy waters post-completion. And we may run into choppy waters with our particular introducer of completed IVAs in the future, because we'll be dealing with clients who haven't come clean during the currency of their IVA. So that's to conclude. As an insolvency practitioner, I think you should be quite robust with your debtor clients about them having to comply with duties and obligations under the IVA to help you to realise whatever financial mis-selling claim there might be. I think you also need to warn the debtor client that you will come after them post-completion if they make their own payment protection insurance claim and don't furnish you with the proceeds. Likewise, if they're running the PPI claim within the IVA, you expect the proceeds too. I still think an equitable view can be taken. I still think you'll be saying to the debtor client, look, this is going to oil the wheels of the machine. This is going to give you a bargaining chip or two in terms of early settlement. It's going to look good. It's going to satisfy the creditors. Now, I will just finally say that all of the above remarks really apply to small and medium-sized insolvency practitioners, because I think when it comes to the large volume operations, they are probably making decent profits. Some of them are also providing loans, So, and if you are a debtor client who's signed up with one of these large volume operations because they've got the money to throw at advertising and marketing and the internet, then, be it on your own head what happens. And you have got better, grounds for griping about your insolvency practitioner making money out of payment protection insurance and you don't make any with those large volume operations. But with the smaller and medium volume operations, insolvency practitioners are struggling to make this work, and they feel it is just an headache like the Paymix issue that they're obliged to deal with, but they could well do without. So don't expect to enjoy any of the proceeds of a PPI claim if you're a debtor client with a small or medium insolvency practitioner. And expect an insolvency practitioner to be robust about ensuring that you comply with your obligations under the IVA, and that will include you complying post-completion if you haven't disclosed, if you haven't cooperated during the course of the IVA. Okay, that's all for today. I look forward to posting again shortly to address part 9 of this 10-part series on best practice post guidance note. Thank you for listening.